Yes, good evening to everybody. Welcome to the today class. That today I'm going to teach you the FIRAC model and IRAC model and read out what is posted on the screen. Anyone can unmute and read what I posted on the screen. Anyone? Okay. IRAC, method of legal writing. So when you are writing the legal writing, especially the problem solving is concerned or the case briefing is concerned, you follow this legal writing and it will be taught in your legal method. And when you go for the LST, that is the Law School of Tanzania, there also they will teach when the case law is given over there, the case briefing will be done in the PFIRAC model and the problem question will be done and attempted in IRAC model. That is the IRAC method of legal writing. So now let us see what is IRAC. So when you say the IRAC, I stands for the issue and the R stands for the rule and the rule of applicable there, and the A stands for analysis or the application, and the C stands for conclusion. Here conclusion is nothing but what the court decision is in general. So IRAC is a acronym for the issue, rule, that is a relevant law, application or analysis, and conclusion. A method used in composing certain legal documents and reports. When the legal documents are there, reports are there, how it can be composed, we will learn it in this method. Now, IRAC, that is IRAC. So IRAC pronunciation is either you can say Iraq, then you can say Iraq also. And here they say IRAC. What its example and observation of the IRAC method is, we will see now. So IRAC, that is in quotation, I quote, IRAC is not a mechanical formula, but simply a common sense approach to analyzing the legal issues. Before the student can analyze the legal issue, of course, they have to know what the issue is. Thus, logically, step 1 in the IRAC methodology is to identify the issue, that is the I, represented by I. Step 2 is the, here step 2 is the, yes, step 2 is the, to state the relevant rules of law that will apply in resolving the issue, that is represented by R. Step 3 is to apply those rules to the facts of the question, that is to say, analyze the issue, that is application, represented by the A, application or analysis, both the way you can use it. Step 4, the last step is to offer a conclusion as to the most likely the result, that is C, conclusion, representative. The conclusion is nothing but what the court held and what the court adjudicated in that case law, or in the problem, if the problem is given to you in the examination. So sample IRAC paragraph, let us see that. So I is the issue, whether a bailment for the mutual benefit of Rough and Touch and Howard existed. That is the issue. What is the issue? Either you can write the whether a bailment or a bailment for the mutual benefit of the Rough and Touch and Howard existed or not. That is the issue. And an example which is given to show what is the issue is. And the rule means either you can say the decided case law or the maxims or the sections or the act, which is sections which are applicable over there to support your issue with the analysis that comes under the application. The R is a pawn is form of bailment. See, R means rule. A pawn means for the movable property we can say pawn, and for the immovable property we can say mortgage. So a pawn form of bailment made for the mutual benefit of the bailee and the bailer, arising when goods are delivered to another as a pawn, PAWN pawn, for the security to him on the money borrowed by the bailer. So money borrowed by the bailer and the bailee, the person who gives the money. And the case law is Jacob versus Grossman case law. In Jacobs, the court found that the bailment for the mutual benefit did arise because the plaintiff pawned a ring, a gold ring or silver ring, as a collateral for the $70 loan given to him by the defendant, that is the bailee. That is an example for the bailer and bailee. In the bailer and bailment, we would say the pawning is done only to the movable property, PAWN pawn. Is it clear? What is the difference between a pawn and the mortgage? Anyone? If you don't know, you say pass on. Don't be idle.
Pass on.
What is the difference between a pawn and a mortgage? Yes?
Pass on.
Pawn is the movable property. Mortgage for the immovable property. Is it clear? In both the cases, interest will only given to him, not the ownership, for getting the loan as a security. Is it clear?
Yes.
Can you repeat?
Pawn
Raman,
is for movable.
go ahead.
Pawn is for movable property and mortgage is for immovable property.
Ownership is transferred in the case, both the cases?
No.
Only interest will be transferred. The movable property which is interest is transferred is the security. In the case of the default, the movable property will be actioned and capital amount as well as the interest will be taken. If any remaining amount will be left over there, it will be given to the bailer. Is it clear?
Yes, Prof.
Okay. A. Application or analysis. In our problem, Howard pawned her ring, a gold ring or silver ring, as collateral to secure an $800 loan given to her by a rough and tough company. So that is the analysis here, application here. And the C is the conclusion. Therefore, Howard and rough and tough probably created a bailment for the mutual benefit. The reason is mutual benefit in the sense the person who pawned will get the money immediately, of course with the interest. But the person who has given the money to him is, because the gold ring is there, suppose if he is a default of it, he can sell it, auction it, and get the money as well as the interest. So that is called the mutual benefit would be there. So when faced with the fairly simple legal problem, all the IRAC elements may fit into a single paragraph. At other time, you may want to divide it into the IRAC elements. For example, you might wish to set out the issue and the rule of law in one paragraph. The analysis of the plaintiff is in second paragraph, and the analysis of the defendant and your conclusion in the third paragraph. And the traditional phrase, yes, very good. Traditional, and the transitional phrase, not traditional. The transitional phrase or a sentence in the first sentence await a fourth paragraph. So we can write in a paragraph wise. The relationship between the IRAC and the court opinions. IRAC stands for the components of the legal analysis. I stands for anyone?
Issues.
R stands for
Rules.
A stands for
analysis.
R application. And C stands for conclusion. And conclusion is nothing but what is the disposal of the case in particular court. What is the relationship between the IRAC and its variations and a court opinion? The court opinion you can write in the last. Sometimes you can write your own opinion also last. Suppose if you don't agree with the statement, the court opinion, yes, you can show my opinion, side heading, last. So that is the way that we can make it out. If you are contradicting with the statement, the opinion given by the court, not necessarily all the opinions will be straightforward. Some opinion will not be quite good. Like I told you, prostitution is a profession, they said, Supreme Court of India. But I will not agree with that point. Because India and Tanzania are having a civilization. They do have their own culture. They do have the fear of God. They do have the mindset. And they do believe that if you do the good deeds and you will be given a heaven in the next world. So such beliefs is there, then you want to make it a legal profession. Prostitution is a legal profession. Then people, instead of working in the Kulima Shamba in the field, they will easily get the money because of the flesh, they can sell it. I mean, the body, they can sell it. So sometimes the decision may be a wrong way, but they say it is the people's right. What people's right? There should be limitations. Okay, because I differ from that opinion. It's my opinion. It should not be given. Yes, it should be, prostitution is an offense. Yes, people do the prostitution, there is a different way. But now it is a license. Is it clear?
I'm not sure, Professor.
Yes?
I'm not sure.
Answer.
For my side, Professor, I'm not sure.
Okay. What? Not sure? Why you are sitting on the wall? Either you jump this side or you jump that side. A firm opinion should be there. For instance, capital punishment. It should be there, it should not be there. Give me the answer, anyone.
It should not be there.
Because your school thought is, you are a humanitarian thought, that is. You should be there because people will kill the people, other people like a animal, like a small bird. If the fear of the killing would not be there, a capital punishment should be there. So judges certainly provide a legal analysis in their opinion. Do the judges follow the IRAC? Yes, they do, although often highly stylized format. In almost every court opinion or judges, they may follow IRAC. Identify the legal issues to be resolved, the I of IRAC. Interpret the statute of the rules. What are the statutes would be there? Maxims are there. Case law is there. An opinion of a particular author would be there as a rule. Our constitutional provisions are there, articles. That all comes under the rule. The R is the rules of IRAC. And provide a reason why rules don't apply to the facts. The A, analysis of IRAC, whether it is applicable or not applicable. In the both the way we can argue it. And that is the analysis or arguments or application. You can make it. And conclude by answering the legal issue through the holding and disposition of the C. What is the disposition of a court? What is the holding of the court? What is the decision of the court? That we will come across in the C. That is the conclusion of IRAC. Each issue in the opinion goes through this process. A judge may not use all of the language of IRAC, may use a different version of the IRAC, because the IRAC can be one version, there is a SERAC is there, and the different versions are there. And may discuss the components of the IRAC in the different order. Yet IRAC is the heart of the opinion, and it is the crux of the case law, gist of the case law. It is the what opinion do. They apply rules to facts to resolve the legal issues. So whatever the rules would be there, they will apply to the facts, and that will be made clear in the argument or application, and its disposition we will see in the conclusion. Alternative format, we can say CREAC, CREAC, or CREAC. This is an alternative form. The IRAC formula in vision of time pressured exam answer. And mostly the people will use IRAC. When you go to the law school of Tanzania, and they will teach the problem question solving in the IRAC model and the case briefing in the model of the P-IRAC model. That is the P-IRAC model. So what's reward in the law school exams tends to not to do the reward in the real life writing. So the coveted IRAC mantra, the rule, hymn, will produce the, excuse me, medicore to the worst result in a memo writing and brief writing. Either memo writing or a brief writing. Why? Because if you were to write a one issue memo using the IRAC organization, you would not reach the conclusion, the answer to the issue until the end. So there are various types of that. Each issue can be written in the IRAC model, but in general, each issue will be dealt in a proper manner and will be written in a one paragraph. Each issue, when you write in the application or analysis or argument. So now, knowing this, of course, quotation is this, some legal writing professors recommend another strategy for writing you do after the law school. They call CREAC, which stands for Conclusion, Rule, Elaboration, and Application. The wordings are different and sequence is different. Of the rule to the facts of the conclusion, restated, although you probably penalized for that organizational strategy on most law exams. And most law exams, we follow the IRAC model for the problem solving. It is actually superior to the IRAC for another type of writing, but it too has a serious shortcomings because it does not really pose an issue. It presents a conclusion to an unknown problem. So preferably that we use IRAC model, not CREAC. And CREAC stands for, it is clearly written, C stands for conclusion, and R stands for rule, and E stands for elaboration, and A stands for application. That is the way it is clearly mentioned. So this is the one way that which I want to share with you. Then another point also it is with me, using the IRAC structure in writing the exam answers. Can anyone unmute and read this in which I highlighted here, so that I could know that you are with me and I am with you, and both are traveling the same boat to reach the destination? Yes. I said, can anyone unmute and read what I posted on the screen, which I highlighted?
Using
The
the
IRAC
I,
method.
See, if you speak, all of the three will speak. Okay, Macmillan, you speak.
The IRAC method is a framework of organizing your answer to a business law essay question. The basic structure is issue, role, analysis, and conclusion. Using this simple framework for structuring your answer will ensure that you have written a complete answer.
Yes. IRAC method is a framework. It is a way of writing. It is a way of presentation in a lucid manner, in a easy manner to understand what the problem it is. Issue. Issue is the question of law. Being your answer by stating the issue presented by the essay question, sometimes the question will provide the issue for you. If not, then ask, what is the legal question that? What answered determines the result of the case. The issue should be stated in the form of a question in the specific rather than the general form. Is there any agency relationship? If there is was no compensation paid? Question mark. Or you can write in the whether. WHETHER also. Would be an acceptable issue. Will the plaintiff win? Would not be acceptable. Not that the issue may be case specific, mentioning the parties' names and the specific facts of the case. For example, it is given here. Did Jones have an agency relationship with the XYZ Corporation due to his acting on behalf of the XYZ and the following its instructions, like an agency and principal? Do you know the principal and the agent? Do you know it? Say yes or no.
Yes.
How many relations are there where the vicarious liability will stand? Vicarious liability will stand how many relations? There are 3 relations are there for the vicarious liability. Number 1, master and servant. Number 2, principal and agent. Number 3, employer and employee. Is it clear?
Please
Yes,
repeat
sir.
number
In
one,
vicarious
sir.
liability, in the law of tort, the relationship you will make it out. Number 1, master and servant. Number 2, principal and agent. Of course, 4 relationships are there. Next, employer and employee. Then partner and other partners also come. For one partner, another partner, all the partners will be held liable. For the servant act, master is held liable. For the agent act, principal is held liable. Q facit, paralium facit per se. He who does through the others does himself. Q facit per se, paralium. Q facit per se, paralium per se. Paralium facit. He who does through others does himself. That is the equivalent. The issue can encompass all cases which present the similar question. Example, is there an agency created whenever there is an employment relationship? Most cases present one issue. If there is more than one issue to address, then you must write a separate IRAC analysis for each issue. For each issue, they want to say the separate IRAC. But we will make it a cut short. For each issue, we can make a separate paragraph. Separate paragraph, you will write in the analysis. It's enough. Rule. The rule describes law, what is the test applies, what is the maxims, what is the sections, what are the articles, what are the international instruments, what are the domestic instruments, acts. This will come under it. So, example, an agency relationship is created when there is an agreement that the agent will act for the benefit of the principal's directions or control regardless of whether the compensation is paid. So, here the relationship between the principal and agent, and for that which section will come and what act would be applicable and what is the case law would be there. For the agent act, the principal is held liable under the liability of the vicarious, and such a thing will come into the picture, and what are the decided cases would be there, that will come under the rule. The plaintiff was the defendant agent would not be an acceptable rule. Don't use the parties, names or specific facts from the case. Hint is frequently the rule will be definition of the principle of law applicable in the case. What is the rule? What is the definition? What is the applicable law? What is the article? What is the instrument? What is the section? What is the maxim? That will come under the rule. Example, an agent may not use or disclose the confidential information acquired through the agency absent an agreement to the contrary. So an agent would be there, he will not disclose any trade secret of their business. Because if an agent will does it, for the agent act, principal would be held liable because the fiduciary relationship is there and the vicarious liability will come into the picture, especially in the civil liability is concerned. So analysis or argument or application. You apply the rule to the facts. For each fact, material, you apply the rule and that you can analyze. Not fact, issues. The rule you apply. No, the rules apply to the facts and that we discuss in the analysis. I repeat, rules apply to the facts and that make the explanation in the analysis or argument or application. The analysis is the most important and the longest part of your answer. Yes, it involves applying the rule to the facts of the problem or the question. What is applying to what? Tell me. What is going to apply to what?
The rules applies to the
Yes, Dorcas, tell me.
The rules apply to the facts.
And that will be interpreted in the analysis. You should use the facts to explain how the rule leads to the conclusion. Discuss both the side of the case when possible. Important, don't merely state a conclusion without also stating the reason for it. A reason that you have to show it. And then only conclusion you can make it out. A conclusion without a reason or explanation means that you have not used the rule and the facts to analyze the issue. So you have to show the reason. Because of the reason he won the case, because of this reason he lost the case. And the hint is the rule can be used as a guide to your discussion. Yes, example, suppose the issue is whether A is an independent contractor. Using the facts of the case, explain whether or not they fit into the definition of what is an independent contractor. Do you know what is meant by independent contractor? Yes or no? Do you know who is an independent contractor? Say yes or no, or say pass on. Don't waste the time.
Pass on.
An independent contractor is a contractor. He will not listen to the owner. He will not listen to the employer. He does himself because he is a skilled person. And he completes the work and take the money and go away. At that instance, there is no such a relationship would be there between a person who employed the independent contractor. For instance, you know dozer? Dozers, shovels, bulldozers. If you know it, you tell me. If you don't know it, say we don't know.
We know it, sir.
Yes?
We know it.
Yes. See, for the dozer person, operator, do you teach him how to dig it, how to excavate it, how to make the trench? Answer is no. Because he knows he's a skilled person. In this case, A was told by the foreman what to wear and how to operate the machine and where to report the work each day, giving her little control over the job. But there would be some foreman would be there, he will merely say, from this area to this area you have to trench, you make the excavation, you make the trench. Of course, the width they will give you and they will mark the area and the dozer operator, he does it with his skill, how to use the dozer or a shovel. So if the rule is tested with the multiple factors, then you must analyze each factor by pointing out that the facts to do or not to do fulfill each factor. For instance, you are taking a cab, a taxi. Whether taxi driver is your employee, give me the answer. You are getting a taxi. Whether the taxi driver is your employee. Answer no. He is an independent contractor. He is an independent person.
No.
And he does the job, taking you from the, say from bus stand to the Kijiveni or south, over. But if made in an accident in the meantime, he would be held liable. Either he is the owner or his owner would be held liable under vicarious liability. So analysis will make it out. Apply the rules to the issues. Apply the rules to the, yes, because issues would be there,
Facts.
rules are there, apply to the facts and make the analysis, and that will put it there in the application. Is it clear? Apply rules to
Yes, sir. To the facts.
To the facts.
And issues will be there.
Yes, issues are there, and we will apply it and make the elaboration or argument or analysis or application, and this is the biggest part in the IRAC model, because each issue one paragraph you have to write. I will give the model also. Conclusion, it is nothing but adjudication of the court for that problem in that area. The conclusion is your answer to the issue. Suppose issue framed that whether a master is held liable for the activities of their servant. That is your issue. And what is the rule is there? He who does through the others will does himself. What is the maxim? Q facit parierum facit per se. That is the rule. And this rule you apply to the fact. And the issue will come out automatically. Then say, yes, master is held liable for the activities of their servant. When a servant does anything in the course of the employment. Is it clear?
Yes, sir.
That we will say in the conclusion. In the issue say, whether the master is held liable for the activities of a servant. But the conclusion will say, because we know the rules. What rule? Q facit parierum facit per se. And there is a case law also. With that we can say the conclusion is there. Yes, master is held liable for the activities of the servant when the servant did that act in the course of the employment. So state the result of your analysis. Example, Smith is liable for the negligence. Or therefore, no valid contract was between the A, X and Y. Or if there are multiple issues are there, there must be multiple conclusion as well. Suppose 3 issues, 3 conclusion. 4 issues, 4 conclusion paragraph. And 4 issues, 4 paragraph application. Is it clear? Of course, he has given the sample IRAC analysis. What is their answer? How it can be made? First, the main issues to be addressed, stated. Then next to go to the next rules. What are the rules should be framed over there? And I will give the living example to you, which I already posted to you today in your email. I don't know whether you saw it or not. Did you see it? Yes? Did you check your email?
No, sir.
What the purpose of sending the email to you? I thought that you will read and come to the class. Why can't you check your email at least? No, sir, you check email only once. When you want to go out, every time that you will look into the QO mirror to see that whether you are smart or not. A smart man check the time to time the WhatsApp, time to time email, because notification comes automatically on your screen. 1 or 2 or 3 emails you did not read it. By the notification, at least you can come to the conclusion that, sir, we did not have the time to see the notification also. Sir, we don't have the mobile data. So a living example which I have given is the Smith versus Baker. It is one of the case law that comes under a voluntary not fit area. And here I followed the procedure. The full case law is given. Full decision is given. A full decision is given. How do you write the case brief? You write in the procedure. This is extra. In the procedure, I told you the first title of the case law with the citation. Then who decided the case, which comes beneath it. Then 4 sentences. From where this case has come to this court, number 1. Number 2, who are the parties? Number 3, what are the principles involved? Number 4, what is the adjudication? So here, there was an appeal from the lower court to the House of Lords, where the plaintiff is the employee, sued the employer for the negligence. So employer and employee, plaintiff and defendant, and the cause of action is the negligence, which resulted in the injury to the plaintiff. So negligence part is cleared, plaintiff part is come over there, and the plaintiff was injured. Hence the employer pleaded voluntary not fit. What the employer did? You voluntarily undertaken the work, hence we will not going to get any compensation. So the employer pleaded the voluntary as a defense, but failed to plead it as a defense. And what is the outcome of the court? What is the outcome of the court? What is the outcome of the court? It is there on the screen.
The appeal was
The appeal was dismissed. That is the outcome of the case. Only 4 lines. We will come into the procedure. Next, facts, material facts. The plaintiff in this case is employed to operate the drill in a quarry, and from time to time, the stones were carrying from passing over the head in the sling, in the crane. Sling here means crane, that it carries that sling to one place to another place, and he anticipated or hunched that danger was there. Those who are working beneath in the quarry, but anytime any boulder will fall on it. But generally, when the crane will be moving from one end to another end, they will make a whistle so that the people will go in the safe area. But on the time, it is either he will not make the whistle, or perhaps he is not made the whistle. The people are working beneath it, and one of the boulder fell down on his head, and he'll become a papad. You know papad? Do you know papad?
Yes, sir.
Oh, you go to the Hindi shop, then ask papad. He'll become a small,
Very thin,
a
very
layer
thin
of
layer.
piece of blood, piece of flesh. That is called papad. Kolikanda, Sharadhavu, what do you say papad?
Yeah, yeah. In India, it is one of the supplement in diet.
Yes, it is a supplemented papad, and he crunched it as a flesh, as a layer, like a roti,
Yeah, yeah.
like a chapati.
Uh,
So that is
chapati. Even thinner than chapati.
yes. So the employer pleaded the defense of the voluntary here, and the court decided in the favor of the plaintiff, hence this appeal. That is the facts of the case law. Now the issues are there. What are the issues? Number 1, whether there was a negligent for not taking the measures to safeguard the plaintiff. Second issue, whether the plaintiff has given the free consent to undergo such an injury by continuing in the situation which was dangerous or harmful in nature. Number 3, whether there was a proximate cause between the negligent act of the defendant and the injury sustained by the plaintiff. Fourth, whether the injury sustained by the plaintiff was a foreseeable. And the last one is whether the plaintiff could be entitled for the damages. There are 5 issues are there. And what are the rules for each issue? There is a case law is there, Brith versus Proprietary Birmingham Waterworks Company, that is one case law, and Pitts versus Hunt, another case law. Bowater versus Rowley Rogis Corporation, another case law. Hux versus Lord Advocates, another case law. Overseas Tankship UK Limited versus Morse Dak and Engineering Company, this is a case law regarding the remoteness of damages. And the Lynch versus Nodine, this is another case law. Well, all the case law shows are there. If a person has given the consent, that is not a free consent, because he has to survive, and hence he has given the forceful consent to work over there. At that time, the employer should have to take all the measures to see that he should work, the employee's work should be a safe place. So application has to there, each issue. See, first issue. What is the first issue? Whether there was a negligence for not taking the measures to safeguard the plaintiff. That is the first issue. Now let us see that as to the first issue is concerned, whether the defendant was negligent for not doing anything to do safeguard the plaintiff. Here the defendant is employer. So in the case of the Hux versus Lord Advocates case law, it was held that the post office employees were negligent in leaving the manhole unattended, that the red wrapper to the paraffin lamp was an attractive nuisance to the children. So they put the paraffin lamp with the red light, which is then said to be attractive nuisance to the children, and children went over there to play with it, but they fell down in the manhole with the paraffin lamp, and the paraffin lamp exploded over there, and the children burnt, and the same thing happened. As the present children in the immediate vicinity or shelter was reasonably anticipated, because they know that in the vicinity there are children playing over there. So in the case at the hand of the defendant was negligent for not doing anything to safeguard the plaintiff, regardless his complaint to the defendant concerning the risk of injury. That means merely keeping the paraffin lamp with the red wrapper is not enough. One attendant should be present. A manhole could not be unattended. Is it clear? Say yes.
Yes, but sir, I
Please.
have the question.
Yes, please ask me.
I have, I have the question on rules. Can you write doctrine?
Yes, I told you maxims, doctrines, sections, articles.
Yes.
Yes, that is the rule.
Sir,
Oh,
in this
not
case,
only cases.
sir, in this case, it was decided that the employer was not responsible. Instead, employees are responsible.
No, in this case, no. Employees has given the consent because the consent is not a free consent. A person who works in the quarry, there is no that there is a imminent danger would be there. Even a person who is working in the underground mine, there is a every time there would be a possibility of the danger would be there. But doesn't mean that even though they have given the consent, it is not the free consent. It's a we should not take it out. But all the measures should not be taken over there. Even though all the measures
But
are
here,
taken, yes.
but here, office employees